Everybody please be seated.
This joint session to receive the State of the Judiciary message from Chief Justice Gilbertson is now called to order, and we are privileged to welcome back a dear friend of ours, this community and this state, Bishop David Zelmer, Bishop of the Evangelical Lutheran Church of America here for the state of South Dakota. And I will lead us in the Pledge of Allegiance to our great nation's flag.
A reading from Deuteronomy, the 16th chapter. You shall appoint judges and officials throughout your tribes in all your towns that the Lord is giving you, and they shall render such decisions for the people. Justice and only justice you shall pursue, so that you may live and occupy the land that the Lord your God is giving you. Let us pray. Blessed are you, O Lord our God, King of the universe. We give thanks and praise for the gift of the law that provides order and the protection of your people. We lift up and ask your continued blessing upon Chief Justice Gilbertson, our Supreme Court, our judges, magistrates across the state, that blessed with wisdom, courage, they may judge wisely, and that justice and mercy may prevail. We pray as well for our governor, senators, House of Representatives, all elected and appointed officials, that through their work, their deliberations and leadership, the people of South Dakota might be served, and liberty and the common good might be put forward. In your holy name we pray. Amen.
Amen. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Madam Secretary, please call the roll of the Senate.
Senators Boland, Kamak, Cronin, Kurd, Ewing, Frericks, Greenfield, Haverly, Heinert, Jensen, Kennedy, Killer, Klum, Colbeck, Langer, Maher, Monroe, Nelson, Neseba, Netherton, Norstrup, Otten, Partridge, Peters, Rush, Russell, Soholt, Solano, Stalzer, Sutton, Tapio, Tiedemann, White, Wick, and Youngberg. Mr. President, you have a quorum.
Madam Clerk, please call the roll of the House of Representatives.
Representative Allers, Anderson, Bartels, Bartling, Beal, Bordeaux, Bruner, Campbell, Carson, Chase, Clark, Conzit, Denner, DeSanto, Duvall, Freimuller, Glanzer, Goodwin, Gosh, Greenfield, Hager, Hogard, Hawley, Heineman, Holmes, Howard, Hunhoff, Jameson, Jensen, Johns, Johnson, Kaiser, Carr, Ketwig, Lake, Lateral, Lesmeister, Livermont, Lust, Marty, May, McCleary, McPherson, Mills, Otten, Kent Peterson, Sue Peterson, Pischke, Qualm, Rasmussen, Reed, Roden, Ring, Rounds, Rosem, Schaefer, Shanefish, Smith, Soley, Steinhauer, Stevens, Teason, Tulson, Turbeville, Willardson, Wismer, Woolman, York, Zickman, Speaker Mickelson. Mr. Speaker, a quorum is present.
Thank you, Madam Clerk. Madam Secretary, you have a motion.
Senator Kurd moves that a committee of 3 on the part of the Senate and a committee of 5 on the part of the House be appointed to escort the Honorable David Gilbertson, Chief Justice of the Supreme Court, to the rostrum.
Is there a second? All those in favor of that motion signify by saying aye. Aye. Those opposed, nay. Motion carried. And I announce the escort committees are comprised of Senators Kurd, Maher, and Sutton, and the House is Representatives Qualm, Kent Peterson, Hager, Hawley, and Bartling. Before I ask our new Sergeant at Arms for the House of Representatives, Jim Smith, let's give him a round of applause. Welcome, Jim. Traditionally, how I'm honored to do this is there's a little bio here about the Chief Justice, and I'm going to close the book and not read his bio, but ask as he will be announced for you that we all think of a number of things. Here's a young man who grew up in the shadow of a minister, northeastern South Dakota. We're all born with blank slates, and as the bishop indicated, that we have been imbued by God in the service of others, and one of those is that the ultimate judge will come later. But in this world, through an independent judiciary, individuals, women and men, are elected, appointed to serve, and those that become the leaders then become a Chief Justice. We are fallible as human beings, as we all know, but our systems are the best in the world. For those of you who have lived around the world, it is rare to have an independent judiciary. I've lived in places where there is no independent judiciary, and even more importantly, independent thought, not clouded from the aura of politics or personal vision, but what it is that the people, not the dictators, not the military, not anybody who might be a despot, says is right or wrong. It's the people collectively in our Constitution and our laws. And this Chief Justice and the people that he leads, in my experience of what he imbues and the judiciary that he represents, is an independent view of what we want of our judiciary for a rule of law that sets us apart from any other nation in this world. Thank you for listening to me, and more importantly, it is a great honor for me to call on you, Mr. Sergeant-at-Arms, to please announce the presence of the Mr. Chief Justice. Please proceed.
Members of the House and Senate, family and friends, please welcome Chief Justice David Gilbertson.
Thank you for that warm welcome. If I might be accorded a moment of personal privilege before I start the message, the Lieutenant Governor mentioned that my father was a minister. Well, my mother was a surgical nurse, which had one quip when I became a justice. Minister, nurse, judge. Well, I guess the Gilbertsons will save you one way or another, whether you want it or not. So.
Well done. Well done.
Well, now to the more formal side of the presentation. Governor Dugard, Lieutenant Governor Michaels, members of the legislature, constitutional officers, my fellow justices, judges, unified judicial system employees, and citizens of the state of South Dakota. In March of 1861, as the United States was on the verge of tearing itself apart in a bloody civil war, Congress passed the Organic Act creating the Dakota Territory. This initial government was modeled after the federal Constitution and was divided up into governmental authority of legislative, executive, and judicial branches. In 1889, the Constitution for the new state of South Dakota continued this model. It remains a fundamental bedrock of our Republican form of government. In arguing for the adoption of the United States Constitution, James Madison had set forth the reasons for the necessity of three branches of government. He said, "It may be a reflection on human nature that such devices should be necessary to control the abuses of government. But what is government itself but the greatest of all reflections on human nature? If people were angels, no government would be necessary. If angels were to govern people, neither external or internal controls in government would be necessary." Now, 128 years after the adoption of the South Dakota Constitution, that format continues to stand the test of time and works well for the benefit of all our citizens. There is legislation that produces little and legislation that produces a lot. In the 1880s, German Chancellor Bismarck proposed providing retirement benefits for the working class of the German nation. For a leader known for his military prowess, This social legislation literally shocked the world. The retirement benefits, however, did not begin until the worker reached the age of 70. At the time, the average life expectancy for a German worker was age 55. Thus, the law was in reality an illusion of smoke and mirrors. On the other hand, last year, this legislature passed Senate Bill 54, which for the first time provided broad across-the-board protections for South Dakota senior citizens. Under this act, the protection begins when the South Dakotan reaches the age of 65. As we all know, life expectancy in South Dakota now extends well past that age. As my father-in-law told me, getting old is not for the timid. Senate Bill 54 makes that journey more safe and comfortable. It does so for two reasons. First, it shows that South Dakota and its citizens care about its seniors. Second, it provides significant protection against abuse. The United States Supreme Court has said on many occasions, the right to be let alone is indeed the beginning of all freedom. Senate Bill 54 contains important protections for South Dakota seniors. For the first time, emotional abuse is now a criminal offense. We joined 38 other states in making the perpetrator of emotional abuse civilly and now criminally liable. However, for a violation to occur, the perpetrator must be the elder's caretaker, and the emotional misconduct must be willful, malicious, and repeated. A careless or a negligent act is not a crime. It comports with what United States Supreme Court Justice Oliver Wendell Holmes observed, that even a dog distinguishes between being stumbled over and being kicked. As with domestic abuse, the courts and law enforcement can protect a victim through a protection order and the prohibition against stalking. In the past, many instances of elder abuse were written off as family squabbles because law enforcement and part-time prosecutors were not familiar with which abusive acts were criminal. This law provides funding for the Attorney General to hire a full-time elder abuse prosecutor and a full-time investigator. It is modeled after a successful program in California. Although this position has only been in existence for 6 months, the Attorney General reported to me that the caseload has exceeded his original expectations. There have already been 135 referrals to this new position. The penalty for financial exploitation of an elder has increased from being a misdemeanor to a felony. Previously, a bank or another financial institution suspecting financial abuse of an elder could only report that suspected abuse to federal banking authorities, and that report never made its way to South Dakota law enforcement officials. Now banks may also directly report the matter to the Attorney General, who will maintain a central registry of reports and have the ability to investigate and to prosecute. A civil cause of action is available against a person who financially exploits an elder. Should the elder prevail, he or she can recover compensatory damages, punitive damages, and reasonable attorney's fees in appropriate cases. Senate Bill 54 reins in abuses in the creation of joint tenancy accounts. If a person uses a joint tenancy account to financially damage an elder, the court may sever that joint tenancy and return the funds to the elder unless the other joint tenant can prove financial contribution to the account. If financial misconduct is committed by a person who stands to gain through a will or other device upon the elder's death, the court may order the forfeiture of the perpetrator's interest in the will. A perpetrator will no longer be able to literally and improperly probate an elder's estate while the elder is still alive. While Senate Bill 54 will not cure all aspects of elder abuse, it will make it more difficult to prey on vulnerable elders and easier to protect them. It certainly makes the temptation less inviting and less profitable. As President John F. Kennedy observed, it is as old as the Scriptures and as clear as the Constitution. The heart of the question is whether we are going to treat our fellow Americans the way we want to be treated. Since those elders who need protection cannot be here today, I wish to thank this legislature on their behalf for giving its time and its attention to this most important task. In November of 2015, the press reported on a significant increase in the number of people accused of crimes who could not move forward in the criminal justice system due to questions of their mental capacity. This is not surprising. According to the Kaiser Family Foundation, South Dakota only has enough mental health professionals to meet 15% of the need for mental health services in our state. In the criminal justice context, this matters because before a person can enter a plea to a criminal charge, he or she must have the mental competency to understand the charge and assist in their defense. The number of orders for competency evaluations entered by circuit courts increased from 48 in 2013 to 147 in 2015. This is a threefold increase in just 2 years. Having these people languish in a county jail awaiting competency evaluations is not the right way to treat them. It also clogs the criminal justice system and costs a lot of additional taxpayer dollars. I believe that many of these unfortunate South Dakota citizens are veterans who have run afoul of the law because of PTSD or other service-related problems or attempts to self-medicate or mask their problems through substance abuse. We owe these disabled veterans much more than to warehouse them in a jail cell. Last November, I called for a task force to address the situation and other changes at the intersection of mental health and criminal justice. I was quickly and fully supported by Governor Dugard. Together, we created a task force which brought together 22 key stakeholders in the criminal justice and mental health fields. We met for the first time in March of 2016 and continued to meet monthly until our work was completed last October. The task force received generous financial support from the Leona M. and Harry B. Helmsley Charitable Trust. The task force had 3 goals. 1, to improve public safety and treatment of people with mental illness who come into contact with the criminal justice system. 2, to more quickly and effectively identify people suffering from a form of mental illness. And 3, to better allocate limited local resources in order to improve early intervention and preserve limited jail and prison resources for the violent, chronic, and career criminals. The task force drafted a comprehensive report which details many facets of mental health issues affecting defendants who are facing criminal charges in South Dakota's court system. The report proposes legislation that will be presented to this legislature for consideration. It broadens the definition of professionals authorized to conduct competency evaluations to national standards approved by the American Bar Association. 30% of other states have already proceeded in this direction. This should speed up the process and save significant tax dollars. The report also recommends creating a mental health court pilot project in Pennington County, which is an alternative method to treat people with mental illness issues who come into contact with the criminal justice system. I've requested funding for this pilot project as part of the UJS budget. What is a rural sheriff supposed to do when he stops somebody at 2 a.m. in the morning on a rural road and quickly concludes after talking to this person, something is not right here? To assist rural law enforcement, the task force recommends investment to promote the expansion of crisis services. The task force also recommends the expansion of telehealth infrastructures to provide a telehealth option for competency evaluations, which would be extremely helpful in these rural areas where hands-on help simply doesn't exist. The task force further recommends other proposals. Examples include training in this area for law enforcement, prosecutors, judges, and probation officers to educate them on the signs of mental illness and how to better deal with it in the law enforcement and judicial systems. As President Ronald Reagan once noted, there are no easy answers, but there are simple ones. I would like to thank the members of the task force for their many months of study and hard work that went into the preparation of the report that you now have. This is a fine example of South Dakotans confronting a South Dakota problem and coming up with a South Dakota solution. As the prophet Amos declared over 3,000 years ago, let justice roll down like waters. A new wave of evil has descended upon our citizens. From Sisseton to Hot Springs, from Harding County to Union County, and all points in between, an explosion of addiction, mainly driven by methamphetamine, is occurring both in rural and urban areas of South Dakota. Ask any law enforcement person from the Attorney General down to the officer on patrol, and they will tell you in the last year or two, the problem has exploded. Between 2014 and 2015, drug arrests grew by 20%. Meth arrests increased by 40%. Drug crimes now account for 41% of prison admissions in fiscal year 2016. Judge Susan Sabers estimates in Minnehaha County her criminal docket, 95% of the felony cases she sees are for meth-related offenses, and it's no different in the rural areas. Sheriff Kurt Hall of Falk County estimates that 90% of those in his jail are there because of drug use, and 100% of the domestic abuse calls involve drugs. South Dakota is fortunate to have programs in place for alternative sentencing, including drug, DUI, and veterans courts, as well as the HOPE program. Without these, we would be faced with the unfortunate situation of building a new women's prison and a new men's prison and staffing them on a 24/7 basis. Drug and alcohol courts in South Dakota continue to grow and expand. As of July 1, 2016, we have 8 drug courts, 4 DUI courts, 2 courts that combine both drug and DUI, and 2 veterans courts for a total of 16 courts. This includes a new drug court in Brookings and significant expansions in Minnehaha and Pennington counties. The number of participants served continues to grow. In 2008, the first year of operation for this program, we had only 6 participants statewide. In 2015, we served 314 participants. We now possess the capacity to serve 450 participants on any given day, compared to last year's sailing of only 290. To put it another way, for the first 5 years of the program, from 2008 to 2012, we served a total of 153 people in those 5 years. For the next 4 years, from 2013 to 2016, in those 4 years, we served 616 people. If all goes well, our projections are that for this fiscal year, in 1 year, we would be able to serve 614 people, the same amount we served in the last 4 years. Because of our increased numbers, the cost by participant served has dropped due to economy of scale. The 2015 cost was approximately $9,000 per year per participant. With the increased numbers, the figure has now fallen to $8,300 a year per participant. Compare these figures with the $25,000 a year estimated cost for one person in the penitentiary. We now treat 3 participants in our drug court and alcohol courts for the cost of a single inmate in the penitentiary for the same period of time. The financial savings and human gains do not end there. Our drug and alcohol court participants are parents of 707 children who, if their parents were in the penitentiary instead of in our programs, the children would become wards of the Department of Social Services at $10,000 per year per child. Instead, those 707 children are living with and being supported by their parents. Thus, in 1 year, we saved taxpayers over $7 million in child care costs. Additional savings are realized by not having people with addictions clogging our hospital emergency rooms and placing additional burdens on the medical system paid for by the taxpayers, either in the form of increased medical costs or county poor relief. While these are good numbers, they are only numbers. The human gains are just as important. In March, I had the opportunity to speak at a DUI court graduation in Rapid City. 5 proud people graduated that day. One, with 658 days of sobriety, told of his attempt to defeat alcohol. Although he was only 47 years old, he had been in the penitentiary 5 times for DWI and had failed treatment 15 times. He found sobriety and a new life through the Pennington County DUI Court. Summing up the change in his life, he reflected, "Everything is better from top to bottom." He now occupies a job rather than a prison cell. I would encourage you to attend a drug or alcohol court graduation. They are public events and everybody is welcome. I have yet to attend a graduation where people were not moved by hearing graduates speak about their struggles with addiction and the positive turnaround in their lives experienced as a result of an arrest which led them to one of these fine programs. Sadly, not all of our participants succeed. This past July, a participant graduated from one of our drug courts. His future looked bright. On July 26th, he was found in a hotel room, dead of an opioid overdose. He left behind children who now have no father. We lost a second participant to an overdose in September. We have to face the fact that when we deal with drug and alcohol-dependent criminal defendants, we are fighting an addiction, and a powerful addiction at that. It is a bitter fact of the reality that while we will succeed with a good majority of our program participants, we will not succeed with all. In prior years, the consequences of failure of a program participant were continued addiction and a trip to the penitentiary. With recent introduction of more powerful and lethal illegal drugs into our state, the consequences of failure can now be death. The Veterans Court concept is slowly expanding. There was great excitement in Watertown last spring when the Veterans Court held its first graduation. With the retirement of the program's founder, Judge Robert Timm, Judge Robert Spears, a former Marine, now becomes the program director. Minnehaha County also started a Veterans Court program under the leadership of Judge Mark Salter, who's also a veteran. Pennington County is waiting for full funding to start a Veterans Court. It, however, has started a Veterans Track probation program. It has 128 veterans on probation, 80 of whom are on felony probation. They receive special attention because they have returned from the service with potential service-related problems. At the end of a horrific civil war, President Lincoln said, "Thank God I've lived to see this day. It seems to me I've been dreaming a horrid dream for 4 years, and now that nightmare is gone." We hope veterans who complete our program will be able to put their demons behind them and say the same. These programs could not move forward without the full cooperation of the Veterans Administration in South Dakota. It has given us access to both inpatient and outpatient treatment for veterans who need it. As I mentioned, drugs are becoming an increasing problem in rural areas. The HOPE program was instituted as a pilot program in 2013 to combat the rural drug problem. HOPE stands for Honest Opportunity Probation Enforcement and is modeled after the successful program in Hawaii. As a condition of supervised probation, participants follow the requirements of HOPE probation under the supervision of a specially trained court service officer. The program focuses on drug offenders with a high risk to reoffend. Random, frequent drug testing is a key component of HOPE. There are swift, certain, and proportional sanctions for noncompliance with probation conditions or failing a drug test. The first pilot program was initiated in Walworth County in 2014. It was successful and has resulted in programs in Brown County, Charles Mix County, Tripp County, Gregory County, and several others. The outcome has been positive. A significant number of individuals have been served, and there is a high rate of success. For example, in 2014, we served 11 participants. 1 graduated that year. In 2015, that number grew. We served 53 participants, with 11 graduating. By 2016, we had 96 participants, with 26 graduating. But for this fine program, many of these participants would have been in the penitentiary or would have reoffended, resulting in a penitentiary sentence. Judge Scott Myron, the creative force behind this program, estimates 80% of the people who complete the HOPE program would have failed conventional probation because of continued drug use and addiction. Last year, this legislature recognized HOPE's success and removed its pilot status and allowed statewide implementation of the HOPE program. Statewide protocols have been put in place to ensure consistency. Given the effectiveness of this program, it is the goal of the UJS to use HOPE in a significant number of rural counties across the state, affording offenders the opportunity to remain in their communities under HOPE probation supervision and to stay out of the penitentiary. Probation is a form of supervision for adult convicted felons. It does not get the public attention that incarceration in the penitentiary or a county jail receives, or alternative sentencing programs receive. Yet, there are more people on felony adult probation in South Dakota than in the penitentiaries, the county jails, and the drug and alcohol programs combined. While there have been significant growth in the penitentiary population and in the county jail population and our alternative sentencing programs, the growth of number of people on felony probation is measured in the thousands. For example, in fiscal year 2011, we had 5,130 cases that resulted in felony probation. 6 years later, fiscal year 2016, that number 5,130 increased to 8,634, an increase of over 3,000. These numbers do not reflect the total number of people on probation. We also supervise juveniles, people convicted of misdemeanors, and interstate compact felons that come to us from other states. The result is increased pressure on our court service officers who are responsible for supervising probation. The average individual caseload has increased from 88 per CSO in fiscal year 2011 to now 114. The nationally recommended caseload maximum is 80. The rubber band will only stretch so far before it breaks. Cost is a significant consideration. Were the perpetrators of these 8,634 cases committed by felons in fiscal year 2016 placed in the penitentiary or an alternative sentencing program, those institutions and those programs would be quickly overwhelmed. The state could not afford the increased cost. Yet, if those 8,634 cases committed by felons continue on probation, they are supervised for a cost of $3 per day per probationer. That is a bargain. Does this mean everybody should be on probation? Of course not. Dangerous felons, career criminals, sex offenders, and the like belong in the penitentiary. Those seriously addicted to drugs and alcohol belong in our drug and alcohol courts and other treatment programs. The vast majority of people on adult felony probation, however, remain on or successfully complete probation. In 1862, our first territorial legislature met in Yankton. One of the first acts was to organize local government by counties. The construction of courthouses provided a place where citizens conducted day-to-day legal business that affected their lives. That method continues to this day and will do so in the future. I never tire of getting into the car and visiting one or more of our 64 courthouses. As South Dakota is the land of infinite variety, so are our courthouses. They are large, small, old, new, humble, palatial, and everything in between. 3 predate statehood and are still in use. A courthouse, solely as a structure, serves a very limited function. It is only when one considers what happens in the courthouse walls that these buildings acquire a special and unique significance in our society. Courthouses are used to provide justice, resolve disputes, and keep the peace. While participants come and go, the building, and more importantly, what it is used for, endures. The availability of attorneys in rural areas of South Dakota is essential to the successful operation of our state's legal system. Without them, a courthouse is little more than any other public building. No legal system can operate on autopilot. It takes the professional skills of an attorney to keep the system moving. 48 of our 66 counties have a population of under 10,000. The few remaining urban areas cannot become isolated outposts of justice. If they do, it is only a question of time before they also topple and the entire legal system begins to collapse. South Dakota's rural attorney program continues to be a model for the nation. Its goal is to place licensed attorneys in those counties with a population of under 10,000 by providing financial incentives to the attorney to practice full-time in that rural county for 5 years. The financial incentive is an amount equivalent to the cost of an in-state legal education. The program lends a helping hand to those attorneys who want to establish a law practice in a rural area. Originally, this legislature authorized funding to place 16 attorneys and gave us 5 years to complete the project. Although each county has individual needs, we were able to fill all 16 slots in a little over 2 years. We then received legislative authorization to redirect UJS funds to create an additional 16 slots. We took advantage of the second authorization and now have contracts with 17 counties. The shortage of attorneys in rural areas is not just a problem for the so-called flyover states. 48 of the 50 states have the same rural attorney problem. These states can benefit from the success of our program. I was pleased to be able to spread the word of the South Dakota success when I addressed the American Bar Association in February and a Legal Services Forum at the White House last April. The current law limits participants to counties under a population cap of 10,000. There are, however, smaller municipalities and larger counties that could benefit from program participation. As an example, the town of Wall is hardly a suburb of Rapid City. I will offer this legislature the opportunity to expand the scope of the current program to include municipalities with a population of under 3,000. No additional tax dollars will be required, just expansion of the existing program to include these rural municipalities along with the rural counties. To show the essential nature of the rural attorney to South Dakota, simply think on each topic I am discussing today. How many could function without the direct involvement of an attorney? How many small counties and cities could function without legal services? Will we repopulate the land with attorneys available to all, no matter the locale? Probably not. But as my friend Chief Judge Judith Kay of the New York Court of Appeals observed, we might not be able to move mountains, but we can sure try to nudge them a little bit. South Dakota and its legal community have a vital interest in maintaining competence in all areas of the law, including Indian law. As President Thomas Jefferson declared, if a nation expects to be ignorant and free, it expects what never was and what never will be. Each of our 9 Indian reservations has a tribal legal system and a court. Federal statutes play a significant role in the area. Despite its importance, very few South Dakota attorney practitioners possessed a working knowledge of Indian law when I started practicing law. In 2002, after several years of my urging, the Supreme Court modified its requirements for the South Dakota bar exam and required mandatory testing on the subject of Indian law. The rationale was simple. To pass the South Dakota bar exam, one would have to know the subject of Indian law and be competent in that area of the law. South Dakota was the second state in the nation to test on Indian law. The results have been impressive. The legal profession in South Dakota now, in large part, possesses the legal skills to practice in this area. This puts us on the right path as commerce and other contacts with the tribes increase and federal laws such as the Indian Child Welfare Act have great impact. I am opposed to any modification of our bar exam which would have the ultimate effect of removing Indian law from our legal scene. My position is strongly supported by the Supreme Court and the Board of Bar Examiners. While other states may choose to go with standardized tests that do not include an examination on Indian law, South Dakota's best course of action is to continue to administer our bar exam on an independent basis consistent with the best interests of all our citizens. Cooperation between the tribes and the state must be more than mere words. It must also be deeds. As Benjamin Franklin observed, well done is better than well said. South Dakota's Constitution Bill of Rights guarantees that, quote, all courts shall be open, and every man for an injury done him and his property, person, or reputation shall have a remedy by due course of law. For all too many South Dakotans who could not afford the services of an attorney, this promise is hollow. Trying to navigate our legal system on your own without an attorney carries with it about as much chance of success as doing surgery on yourself. For far too long, the 3 legal aid services in South Dakota that provide legal services to those who cannot afford them have been underfunded and understaffed. Limited federal funds and additional contributions from concerned organizations cannot come close to filling the need that exists. The bulk of the need is in the area of domestic relations. Imagine you, as a parent, having the future custody of your children decided in a court proceeding with you forced to act as your own attorney due to lack of funds. Nationally, 81% of domestic relations cases find one or both parties unable to afford an attorney. They must represent themselves in these important cases the best they can. 3 years ago, I invited the 3 legal service entities to participate in discussions about increased efficiency and coordination. While we had fruitful discussions, the core problem was, and still is, the lack of funding to meet the needs. It is time to have a serious discussion about how this crisis can be solved. I never tire of coming into this beautiful building. It was restored in the 1980s to look as close as possible to the day it was opened over 100 years ago. The source of pride for the citizens of South Dakota is obvious. In 2014, the gorgeous stained glass, which was in dire straits, was restored. There remained, however, one large public area of the building which was not restored, the Supreme Court's Law Library. Every time an appellate court issues a decision, it is carefully recorded in a law book. Over the decades, that amounted to a lot of law books that were continually added to the Supreme Court's law book collection. It was only a question of time before we ran out of space for more books. Then about 10 years ago, technology stepped in and made the bulk of the legal research materials available online. Literally overnight, the necessity for a significant portion of the law books disappeared. This allowed the Supreme Court to contemplate restoring the law library to how it looked in 1911 when the building was opened. Unfortunately, we did not know what the law library originally looked like. Then, through a bit of luck, we located a 1911 copy of a publication called Western Architectural Digest, which showcased a photograph of the law library when this capitol was opened. Armed with this picture and the ability to discard law books replaced by computer terminals, we started to hunt for a rumored mural covered by the bookcases. However, removal of the second-floor mezzanine bookcases established there never was a missing mural. While the rumor had the makings of a great story, in the end, it was not factually accurate. However, we did find names of distinguished Dakota Territorial and early South Dakota Supreme Court justices painted at the top of the library walls. For some unknown reason, these names, along with all the gorgeous patterns and stenciling, had been painted over long ago. Beautiful hardwood floors were covered up with now well-worn carpets. Vintage Victorian brass lighting was discarded in favor of functional but ugly fluorescent lights. After careful research and restoration work by people who take great pride in their crafts, You are now invited to step back into time and view the Supreme Court Law Library as it looked when the building was open. While most of my tasks as Chief Justice are important and interesting, very few qualify as fun. This project was fun. And we take great pride in now having a fully functioning Supreme Court Law Library that carefully preserves the past. You're invited to visit it during our normal business hours. For the past year, it's been my privilege to serve as president of the Conference of Chief Justices. This is an organization made up of the Chief Justices from all 50 states, the District of Columbia, Puerto Rico, and the Pacific Territories. This has been an interesting and an intense year, and I've learned much from my contact with these jurisdictions. It is clear that each jurisdiction has its own legal needs and challenges. The message I wish to bring to you today is that based on what I have observed in the past year, South Dakota's legal system, while not perfect, is heading in the right direction and stacks up well in its attempts to meet the legal needs of our citizens and those who enter our state. To quote that sage philosopher, Dorothy in The Wizard of Oz, Toto, there's no place like home. When I was growing up in the 1950s in this state, it was clearly a simpler time. Most houses had front porches. In the evenings in good weather, one would sit on the porch and visit with people who happened to stroll by. Everyone knew everyone else, so this was a way of communicating face-to-face rather than by smartphones. It was a long way to maintain cordial relationships with the neighbors. Gone are most front porches. They have been replaced with backyard decks with privacy fences around them. While I have no complaint with a person seeking privacy, some of the concern one neighbor once had for another has been lost. Hopefully the programs that I have reviewed today will help fill that void. As Mark Twain once observed, 20 years from now, you will be more disappointed by the things you didn't do than the ones you did do. With technology, attention spans seem to be getting shorter. We should not pass by on the other side of the road like the priest and the Levite in the parable of the Good Samaritan. The most important part of a person's life is the impact it had on others. Well, this completes my report to you. I would like to hopefully avoid the observation of a church attender who once told my father about another minister. He said, his sermon was too long. He had 7 good chances to quit and missed them all. So, with that, thank you for your attention, and God bless the state of South Dakota and this legislature.